Welcome back to the deep dive. We have a stack of documents today that...
I mean, it's a masterclass in how institutions handle, or honestly mishandle, scrutiny.
Right. So for you listening, we are looking at a massive communication breakdown between a citizen, David Rivolo, and the public information officer for the Orange County Superior Court, Kostas Kalaitzidis.
And we aren't just looking at a few angry emails here. We are analyzing a timeline stretching from 2022 to 2026 involving thousands of data points, metadata signatures, and eventually the Department of Justice.
Exactly. Our mission today is to unpack how this relationship went from sharing personal cell phones to filing police reports.
Right.
We want to see what specific data points, like metadata and even punctuation, what they reveal about the tension between government transparency and institutional self-protection.
So let's just start at the beginning. Phase 1, back in June 2022, we can call this the honeymoon phase.
The honeymoon phase.
Yeah, Ruvolo is requesting things like oaths of office and staff lists, just standard administrative stuff.
And the response from Kalaitzidis was surprisingly warm, right? He actually gave Ruvolo his direct cell number, 5205481.
Which is...
That feels like a gesture of friendship, or at least extreme helpfulness.
It feels that way, but let's look closer. In the world of institutional PR, giving out a cell number isn't usually about making friends. It's a tactic.
Oh, I see.
It moves the conversation off the official trackable email server and into verbal, informal channels. It's a way to manage a persistent requester without creating a permanent paper trail.
That makes total sense. But the friendly vibe didn't last long at all. By September 2022, we hit the turning point.
Right.
There was a dispute over records related to PC 1214B. Ruvolo thought they were administrative records, and the court said they were adjudicative.
And this is where the exclamation point incident happens. Kalaitzidis fires back an email saying, David, the documents you are asking for are adjudicative records and not administrative records.
With 4 exclamation points.
4.
In a professional setting, that is basically a scream.
It absolutely is. It signaled a total breakdown in decorum. In that moment, Ruvolo shifted from a citizen to be helped to a threat to be managed.
And managed meant escalation. By 2023, the court actually filed a report with the sheriff claiming Ruvolo was making threats.
Which law enforcement deemed entirely baseless. They found no victim and no crime.
But the filing itself acts as a deterrent.
It does. However, what fueled this conflict wasn't just attitude, it was the forensic oddities Ruvolo started uncovering.
This is the part that blew my mind. Let's talk about case 04HN00177. Ruvolo gets a PDF of the file and notices page 8 of 9 is missing.
Just gone.
Just gone.
Right. And when he pointed out, they magically provided it. But then there's the allegation of a Photoshop signature on a probation order in that exact same file.
Because Ruvolo claimed the digital artifacts looks manipulated.
Yes.
And then there's the zombie ID.
Ah, the zombie ID.
Ruvolo found a CCMS ID attached to records in 2024. Why is that weird?
Because the CCMS system was defunded and supposedly killed off in 2012.
Right.
So seeing a ghost system ID in a modern record suggests there is back-end machinery or legacy data handling that the public just isn't supposed to see.
He also flagged transparency reports from the district attorney's office where case numbers were allegedly removed, basically spoliating evidence.
To a requester, these look like evidence tampering. To the institution, Ruvolo's persistence in pointing them out makes him a huge liability. It's what we call strategic silence.
Strategic silence.
They fix the undeniable clerical errors like the missing page, but they go completely radio silent on the deeper questions about signatures and legacy systems.
Speaking of silence, let's talk about the psychological warfare aspect. Ruvolo used MailTrack on his emails.
This is a crucial detail. In October 2025, Ruvolo could see that one of his emails was opened 80 times in 3 days.
80 times.
And yet no response. That is a very specific kind of power play. It tells the requester, we are watching you, we are obsessed with what you're saying, but we will not acknowledge you.
So where does that leave us right now?
As of 2026, the Public Information Officer Kalaitzidis has effectively gone dark. The General Counsel, John McCoy, has taken over and is treating this as a legal defense matter.
Wow.
And Ruvolo has escalated to the U.S. Department of Justice alleging civil rights violations.
So Kalaitzidis isn't a bridge to information anymore.
No. He's functioning as a shield for the institution, using Rule 10.500 over, not to reveal, but to deflect.
It's a stark transition from calm myself to talk to the DOJ.
It really is. It highlights that in these bureaucratic battles, the line between clerical error and active concealment is often drawn by who controls the metadata.
That is a heavy reality. So here's a final thought for you to chew on today. If a public institution tracks your emails 80 times in 3 days, but refuses to answer simple questions about missing pages, where exactly is the line between bureaucratic inefficiency and active concealment? Thanks for joining us on this deep dive.